Hello, my name is In-Ho Song. I'm a criminal defense attorney with law firm HYUN in South Korea. Today, I'll explain what happens when a foreign national becomes involved in a criminal case in South Korea. This video is mainly for people from the United Kingdom and the United States and for their families. You may have received a sudden phone call saying that your son, daughter, spouse, friend, or colleague has been arrested in Korea. You may not speak Korean. You may not know where they are being held. And you may not know whether they have already been charged. In that situation, the most important thing to remember is this. An arrest in Korea does not automatically mean that the person is guilty. It does not always mean that the person has already been formally charged, but the first 24 to 48 hours are extremely important. So in this video, I'll explain the Korean criminal procedure step by step. Let's begin with the overall process. A criminal case in Korea usually starts with a police investigation. The person may be questioned as a suspect, and in serious or urgent cases, they may be arrested. If the authorities want to keep the person in custody, prosecutors must ask a judge for a detention warrant. The judge then holds a detention warrant hearing. At that hearing, the person may either be released or remain in custody while the investigation continues. After that, the case may be sent to the prosecutors. Prosecutors then decide whether to indict the person. If the person is indicted, the case goes to criminal trial and the court eventually gives a judgment. Depending on the case, the results may be not guilty, a fine, a suspended sentence, or imprisonment. The key point is simple. In Korea, arrest, detention, indictment, and conviction are totally different stages. They are not the same thing. Many families hear the word arrested and immediately think, has my family member been charged? Or are they going to prison? But at the early stage, the person is usually a suspect. A suspect is someone being investigated, not a convicted person. Even if the police believe there is evidence, prosecutors still have to review the case. Only if prosecutors decide to indict does the person become a defendant in court. So, when someone is arrested in Korea, the first practical questions are very concrete. Where are they being held? When exactly were they arrested? What is the alleged offense? These questions matter because the early timeline can move very quickly. Okay, now let's talk about the most urgent period, the first 24 to 48 hours. In some cases, Korean authorities may arrest a suspect without a warrant. This may happen in urgent situations or when the person is caught at or near the scene of an alleged crime. In drug cases, violence cases, sexual offense cases, or cases involving an alleged victim, the authorities may treat the matter very seriously from the beginning. They may be concerned about flight risk, destruction of evidence, or possible accomplices. However, if the authority want to keep the person in custody after an emergent arrest, prosecutors must ask a judge for a detention warrant within a very short legal deadline. This deadline is 48 hours from the time of arrest. If the warrant is not requested in time, the person must be released. If the judge refuses to issue the warrant, also, the person must also be released. But release does not always mean the case is over. The investigation may continue, and there may also be immigration issues, such as an exit ban or visa problem. Still, release is extremely important because it allows the defense to prepare the case outside custody. Police questioning is one of the most important parts of the case. A foreign suspect should understand 3 basic rights. They have the right to remain silent. They have the right to assistance from a lawyer. And if they do not understand Korean, they have the right to interpretation. This matters because the police and prosecutors in Korea often prepare written statements after questioning. Those written statements can later become very important evidence. So, a suspect should not sign a Korean language document unless they clearly understand what it says through a competent interpreter. Later, some foreign suspects say, "I signed because I was scared," or "I thought it was just a form." But once a document is signed, it can create serious problems. During questioning, the suspect should be careful, calm, and accurate. They should not guess, exaggerate, or agree to facts they do not actually understand. In a criminal case, one inaccurate sentence can change the direction of the entire case. If prosecutors request a detention warrant, the suspects will usually be brought before a judge. This procedure is called 영장실질심사 in Korean. In English, we can just call it a detention warrant hearing. This is not the main criminal trial. The judge is not deciding final guilt or innocence. The judge is deciding whether the suspect should remain in custody while the investigation continues. The court usually looks at three main issues. First, is there a reasonable suspicion that the person committed the alleged offense? Second, is there a risk of flight? Third, is there a risk of evidence destruction? For foreign nationals, prosecutors may argue that there is a flight risk because the person can leave Korea. That is why the defense must prepare concrete materials such as residence information, employment ties, family circumstances, medical issues, and reasons why detention is not necessary. A detention warrant hearing may happen very quickly. That is why early defense preparation is essential. If the judge grants the detention warrant, the suspect may remain in custody while the investigation continues. This is still not a conviction. It means the court has allowed detention during the investigation. The case will then continue through the police and prosecution stages. The police may continue investigating and send the case to prosecutors. Prosecutors may conduct further investigation and decide whether to indict. If the person is indicted, the case goes to trial. Criminal trials in Korea are conducted in Korean, so a foreign defendant may need interpretation in court. The defense lawyer reviews the evidence, submits written opinions, and argues both legal and factual issues. If necessary, the lawyer also prepares sentencing arguments. In serious cases, the defense must examine not only what the evidence appears to show, but also how it was collected. One common question from American families is, can we pay bail? This is understandable, but Korea does not work exactly like the American cash bail system. There are procedures to request release from detention. Depending on the stage of the case, the defense may consider a review of detention, a request to cancel detention, or bail after indictment. But families should not assume that paying a fixed amount will automatically secure release. The court will consider the seriousness of the charge, the risk of life, the risk of evidence destruction, and other circumstances. So, the real question is not simply how much is bail. The real question is what legal procedure can be used at this stage, and what evidence do we need to persuade the court? Another common question is, can the embassy get them out? The answer is no. The British Embassy or the United States Embassy can provide important consular assistance. They may help confirm the person's welfare, visit the detained person, or raise serious concerns about medical care or mistreatment. But the embassy cannot act as a criminal defense lawyer. It cannot give Korean legal advice, pay legal fees, or force Korean police, prosecutors, or courts to release the person. The embassy is an important support channel, but it is not substitute for Korean criminal defense lawyer. If your family member has been arrested in Korea, try to confirm the following information as soon as possible. Please confirm the person's full name, date of birth, nationality, and passport information, and Confirm the police station, detention facility, or investigation office where they are being held. Confirm the exact time of arrest and the alleged offense. Confirm whether they have already been questioned, whether they had an interpreter, and whether they signed any document. Confirm whether a detention warrant hearing has been scheduled. Also, check whether they have any urgent medical conditions or medication needs. And confirm whether the embassy or consulate has been notified. If the case involves drugs, violence, sexual offenses, immigration issues, or an alleged victim, it is even more important to act quickly and carefully. Do not assume that the procedure is the same as in the United Kingdom or the United States. Korea has its own criminal justice system, timelines, and legal standards. To summarize, an arrest in Korea is serious, but it is not the same as a conviction. The first 24 to 48 hours are critical. A detention warrant hearing is not the main criminal trial, but it can decide whether the person remains in custody. And early legal representation can make a real difference. If your family member has been arrested or detained in South Korea, time matters. You should not try to handle the situation alone, especially if you do not understand the Korean criminal justice system. We assist foreign nationals and their families in criminal cases in South Korea. If you need urgent legal assistance, please contact us through the contact information shown on the screen or in the video description. We will help you understand the procedure, protect the suspect's rights, and respond as quickly and carefully as possible. Thank you for watching.